On the night of October 14, 2025, in Montecito, California, a call reportedly came through that changed the direction of everything. It was not a family check-in. It was not a scheduled briefing. According to people familiar with the moment, it was a legal notification rooted through international counsel, and it carried consequences that could not be softened by protocol. The message originated in Paris. It referenced a formal civil filing. The figure attached to it was $8 million, and the name at the top of the document belonged to one of the most powerful luxury houses in the world. Chanel. For years, disputes involving high-profile figures have often been handled quietly. Settlements are reached, statements are drafted, problems disappear before the public ever notices. That outcome was reportedly expected here as well. Sources say Prince Harry believed the situation would be managed the way previous crises had been managed, through distance, discretion, and intervention from London. That expectation proved wrong. According to multiple individuals with knowledge of the response, the call placed overseas did not result in reassurance. It did not produce a plan, it produced a boundary. The message conveyed back was simple and final. This matter would not be handled by the palace. The decision stunned those who heard about it, not because the allegations were minor but because they were not. The filing, according to people who reviewed it, outlined what Chanel described as a sustained pattern rather than an isolated incident. 18 months, dozens of transactions, repetition documented across time. From the outside, appearances had remained polished, public events continued, images circulated, nothing appeared amiss. But behind that surface, a different picture was taking shape, one built on logs, audits, and internal reviews. According to sources, the number 47 appeared repeatedly in documents tied to the case. 47 high-value items, 47 returns, a level of consistency that raised questions even among seasoned retail analysts. What made the situation more complex was timing. The filing did not arrive during a moment of strength. It arrived during a period of financial recalibration. Without institutional backing, legal exposure takes on a different weight. The immediate question was not whether the lawsuit would proceed. It was why Chanel chose to proceed publicly at all. Brands of that stature rarely do so unless they believe their evidence can withstand scrutiny. That belief, according to people familiar with the case, was built over time. And it began with a pattern few outside the luxury industry ever notice, until it becomes impossible to ignore. Long before the lawsuit became public, people inside the luxury retail world say concerns had been quietly accumulating. Not alarms, not accusations, just inconsistencies that only make sense when viewed together over time. According to individuals familiar with high-end fashion operations, brands track return behavior with extreme precision, especially when items cross into five-figure territory. Returns happen, even among elite clients, but repetition changes how those returns are interpreted. Frequency creates profiles. Profiles invite review. Beginning in early 2024, internal systems at several boutiques reportedly flagged a customer pattern that stood out. Purchases would be made shortly before high-visibility appearances. The items would then reappear at boutiques within standard return windows. On paper, nothing violated policy. In practice, the cycle repeated too cleanly. Sources say experienced sales staff noticed the same rhythm again and again, the same sequence, the same urgency. Items would leave stores pristine, they would appear under bright lights, then they would come back packaged as new. Over time, the number of instances grew difficult to dismiss. What made this sensitive was the profile involved. High-status customers often receive the benefit of doubt. Questions are softened, escalations are delayed. According to retail managers, no one wants to be the person who challenges a name that draws attention. But documentation does not care about names. By mid-2025, several luxury brands had reportedly begun tightening internal notes. Transactions were logged more carefully. Serial numbers were cross-referenced. Patterns were compared across locations. What had once seemed coincidental began to look consistent. Fashion analysts point out that this is how many internal investigations begin. Not with a single incident, but with accumulation. One return is forgettable. Two raise eyebrows. Dozens form a narrative. At the same time, public appearances continued uninterrupted. Editorial coverage identified designers almost instantly. Fashion blogs tracked looks across events. Observers noticed how often items appeared once and never again. Individually, that meant nothing. Collectively, it added context. According to people familiar with the case, Chanel's internal compliance team became involved after return frequency crossed a threshold. Unlike many brands, Chanel maintains an internal quality review process for high-value disputes. When that process is triggered, items are no longer treated as retail stock. They are treated as evidence. This was not about embarrassment, it was about risk. By the time preparations began for the San Isidro event, sources indicate Chanel was no longer operating on assumption. They were observing, documenting, allowing behavior to repeat to confirm whether concerns were justified. They were not trying to stop a return. They were trying to understand a system. And what happened after that event, according to people who reviewed the findings, is what pushed this situation from internal concern into formal legal action. According to people familiar with the internal review, the item worn to the San Isidro event was treated differently from the moment it left the boutique. It was logged, tracked, and flagged for secondary inspection before it was ever returned. This was not routine, it was deliberate. When the garment came back the following morning, store staff reportedly followed standard procedure on the surface. The tag was attached. The packaging looked intact. There were no visible stains. Under normal circumstances, it would have been cleared and returned to inventory within minutes. Instead, it was isolated. Sources say the item was transferred to Chanel's quality assurance facility in Paris, a department that operates more like a forensic lab than a fashion house. High-value pieces flagged for dispute are not cleaned or altered. They are preserved exactly as received. Every fiber becomes data. The first anomaly reportedly appeared under ultraviolet light. Chanel's proprietary security fasteners contain a compound designed to fluoresce under specific wavelengths. This one did not. The tag itself was authentic. The connector was not. According to the filing, the fastener had been replaced. That discovery prompted deeper analysis. Technicians then examined stress points in the fabric, focusing on areas that experience friction during extended wear. According to people who reviewed the report, microscopic inspection revealed cosmetic residue embedded well beyond the surface. Not a smudge, not transfer from handling. Pigment worked into the fibers. The pigment was analyzed. Sources say its chemical profile closely resembled a specific bronzing product publicly associated with the wearer. The distribution pattern suggested sustained contact over time, consistent with hours rather than minutes. Then came scent analysis. Luxury houses employ specialists trained to identify fragrance absorption. According to the report referenced in the filing, the garment carried layered scent notes inconsistent with storage or boutique environments. Instead, the fibers held oils matching a personal hair product known for its distinctive composition. Experts say this level of absorption requires heat and prolonged contact. But the most consequential finding, according to people familiar with the case, involved biological material. The filing alleges that technicians recovered skin cells and hair fragments trapped within the weave. These samples were preserved in sterile conditions. While no public DNA match has been disclosed, the presence of identifiable biological material was cited as inconsistent with a brief fitting. Taken together, these findings formed the foundation of Chanel's claim. A returned item with altered fasteners, embedded cosmetics, absorbed personal scent, and biological traces does not meet the standard of unworn merchandise. Legal analysts say this shifts the argument from mistake to misrepresentation. Chanel's position, as described by sources, is straightforward. Packaging can be restored, tags can be reattached, but physical evidence cannot be erased once an item has been worn under real conditions. At this stage, the issue moved beyond fabric and fasteners. Investigators began looking for something that could establish intent rather than condition. And that search, according to people familiar with the filings, led them to recorded conversations that would become central to the case. According to people familiar with the legal strategy, Chanel's attorneys anticipated that physical findings alone would be challenged. Fabric can be debated, scent can be argued, even biological material can be explained away, so investigators reportedly focused on something harder to dismiss: intent captured in real time. That effort led them to unused production footage. When large documentary projects are filmed, cameras record for hundreds of hours. Most of that material is never aired. It remains archived, untouched, and rarely reviewed. According to sources close to the case, Chanel's legal team requested access to raw footage connected to appearances where disputed garments were worn. What they allegedly found shifted the trajectory again. One segment described by individuals who reviewed it was filmed inside a private residence during preparations for a formal event. The mood was calm. Wardrobe adjustments were underway. The garment was already being worn. As cameras continued rolling, discussion reportedly moved away from styling and toward logistics. The topic was the tag. According to sources, voices on the recording discussed keeping the tag hidden so it would not appear in photographs. The conversation then turned to securing it in a way that would allow it to be reattached later. Observers say the tone suggested familiarity, not improvisation. Then came a remark that legal analysts reportedly found significant. As someone handed over a drink, a voice was allegedly heard joking about avoiding spills because otherwise the item would have to be paid for. According to those familiar with the audio, the implication was clear. Ownership was framed as a failure state. Return was assumed. In legal terms, that matters. It suggests intent existed before the event, not after. It reframes the act from a return dispute into an alleged plan formed at the point of purchase. That distinction is critical when assessing claims of misrepresentation. Investigators reportedly continued expanding the scope. Additional audio was allegedly sourced from boutique security systems. One incident described in the filing involved a return refusal due to visible wear. According to the lawsuit, recorded audio captured a heated exchange in which an associate was pressured to override policy. The language, as summarized by sources, referenced influence and reputational threat. People familiar with retail compliance say this pattern is recognizable. When challenges are met with escalation rather than explanation, internal flags are raised. When the same response appears across locations, it becomes documented behavior. At this point, analysts say the case stopped being about one brand. It became about whether a system existed that produced repeat outcomes. That question naturally drew in another discipline: forensic accounting. According to the filing, several purchases were not made using personal cards. They were allegedly routed through business entities associated with media production. On its own, that is not unusual. In combination with returns, it invites scrutiny. If items are expensed, deducted, and then refunded without correction, the issue moves beyond retail policy. According to tax professionals, repetition and documentation are the determining factors. This is where another name entered the conversation: Prince Harry. Because while recordings and wardrobe decisions may have involved others, financial records reportedly pointed to accounts bearing his name. Refunds, statements, ledgers, details that suggested proximity rather than distance. For observers, this was the moment the situation expanded from image management to potential exposure. And exposure, once documented, demands a response. As awareness of the filing spread quietly through legal and fashion circles, the initial reaction was not outrage. It was caution. According to people who track luxury brand litigation, Chanel's willingness to proceed publicly signaled confidence rather than impulse. Brands of that size rarely expose themselves without preparation. One detail stood out almost immediately. There was no direct denial. No statement addressed the specific allegations described in the filing. No explanation was offered to counter claims about altered fasteners, forensic findings, or recorded discussions. Legal representatives, when approached, reportedly declined to comment on details. In situations involving high-profile figures, silence is sometimes strategic, but prolonged silence carries its own interpretation. Industry observers say this absence mattered. When allegations are clearly false, responses are often swift and precise. When responses are delayed or avoided, it suggests counsel is weighing risk rather than rebuttal. Within fashion circles, practical consequences followed. According to stylists familiar with the situation, informal conversations changed tone. Loan arrangements became stricter. Some brands reportedly paused collaborations entirely, not as punishment, but as risk management. Luxury operates on trust as much as image. Media coverage evolved in stages. Early reports used careful language and emphasized allegations. As more context surfaced, analysis shifted toward pattern recognition. Commentators focused less on individual claims and more on the consistency described across time, locations, and transactions. Then there was the response from the palace. Or rather, the lack of ones. Despite intense speculation, no background briefings emerged to soften the narrative. No unnamed aides offered reassurance. Requests for comment reportedly went unanswered. For those familiar with royal communication strategy, this silence was notable. It suggested a decision had already been made. According to people familiar with internal discussions, the matter was classified as private commercial activity. That classification matters. It determines whether institutional resources are engaged. In this case, they were not. Behind closed doors, advisors reportedly warned that any involvement could blur lines that had been deliberately drawn. Financial independence had been emphasized publicly. Reversing course now would invite scrutiny not just from press, but from oversight bodies. This posture effectively left the dispute to unfold without intervention. For those watching closely, it marked a clear shift. The safety net many assumed existed was not being deployed. As days passed, attention moved from whether help would arrive to what consequences might follow without it. Legal exposure increased, costs mounted, and the reality set in that this situation would be governed not by tradition or status but by procedure. That realization reframed everything that followed. Once it became clear the palace would not intervene, the consequences widened quickly. What had once been discussed as a reputational concern now carried defined legal and financial weight. According to people familiar with similar disputes, the absence of institutional backing changes leverage immediately. Settlement dynamics shift, timelines compress, costs escalate. The most visible consequence was financial exposure. An $8 million claim is not symbolic. Legal analysts note that figures of that size typically reflect calculated damages, internal investigative costs, and a punitive component meant to discourage repetition. It signals that the plaintiff believes its evidence can justify scrutiny in open court. Beyond the civil claim itself, attention reportedly turned to regulatory implications. When allegations involve repeated refunds tied to business entities, compliance agencies take interest. Former auditors explained that patterns matter more than intent in early review stages. Repetition alone can trigger examination. This is where the stakes moved from uncomfortable to serious. If purchases were classified as business expenses and later refunded without corresponding corrections, the issue becomes one of inaccurate reporting. That carries consequences far beyond retail loss. Back taxes, penalties, and audits are procedural outcomes, not hypotheticals, according to tax professionals. Observers also noted collateral effects. Business partners reassessed exposure. Insurance coverage was reviewed. Risk profiles were updated. In industries built on reputation and reliability, uncertainty has a chilling effect. Deals pause, invitations slow, momentum stalls. For Prince Harry, the implications were reportedly personal as well as legal. Financial records bearing his name place him closer to the transactions than public narratives suggested. In regulatory matters, proximity often matters more than explanation. Being listed on an account is sufficient to invite review. Sources say advisors made that clear. Distance would have to be demonstrated with documentation. Explanations would have to align precisely with records. Inconsistencies would not be treated generously. At the same time, the monarchy faced its own calculus. Any financial assistance could be construed as interference. Any attempt to resolve the matter quietly could be interpreted as shielding private conduct. Advisors reportedly concluded the cost of involvement outweighed any benefit. This is why the decision not to act was framed internally as preservation rather than abandonment. Protect the institution, maintain boundaries, allow private matters to be resolved privately. For those involved, this marked a point of no return. Without buffers or intermediaries, the dispute would now unfold in public view, governed by procedure rather than precedent. And that reality reshaped everything that followed. As things stand now, the case remains active and unresolved. According to people familiar with the procedural posture, preliminary filings continue to move through early stages, and neither side appears to be positioning for an immediate settlement. That alone suggests confidence from the party bringing the claim. Notably, there has still been no detailed public response addressing the specific allegations described in the filing. No point-by-point denial has been issued. No alternative explanation has been offered for the physical findings, the recorded conversations, or the transaction patterns. Legal teams have reportedly opted for restraint, but observers note that silence becomes louder as time passes. Several questions remain central. Why do records allegedly show the same return behavior repeating across months and locations? Why were refunds reportedly processed through multiple accounts tied to business entities? And why has no documentation been produced publicly to clarify whether refund D items were corrected in financial reporting? Industry insiders say these questions matter because they establish pattern rather than accident. One questionable return can be explained. A handful may raise eyebrows. Dozens, documented across time, suggest something systematic. There is also the matter of evidence that has not yet been seen. Sources close to the case suggest additional materials exist, including internal correspondence, store logs, and further audio recordings that have not been introduced publicly. Whether those materials surface may depend on how aggressively the case proceeds. Attention has also turned to timing. Legal analysts note that delays often favor plaintiffs when evidence has been preserved early. Physical items do not change. Records remain fixed. As cases stretch on, narratives are tested against documentation. For the palace, the current posture appears unchanged. Distance has been maintained. No signals of reconsideration have emerged. According to those familiar with royal protocol, once a boundary is drawn this clearly, reversal is rare. This leaves the individuals at the center facing a reality shaped not by status but by process. Courts move methodically. Brands defend their interests carefully. Outcomes are determined step by step, not by public sentiment. What remains uncertain is how far this will go. Whether it concludes with settlement, proceeds to trial, or expands into regulatory review is still unknown. But those watching closely agree on one point. This situation has moved beyond speculation. It has entered the realm of consequences. What remains after the filings, the silence, and the distance is a clearer understanding of what independence actually costs. For years, autonomy was framed as liberation from constraint. But autonomy also removes insulation. It replaces tradition with procedure. It replaces quiet fixes with public records. Those watching this closely point to a single turning point. Once institutional protection was withheld, the rules changed. There were no intermediaries left to soften outcomes, no discrete channels to absorb damage. What remained was a private dispute unfolding in full view, governed by documentation rather than deference. That is why this moment feels different from past controversies. This is not about optics alone. It is about systems colliding. A global luxury brand built on precision confronting behavior it believes undermines trust, financial records intersecting with personal narratives, silence meeting evidence. For the monarchy, the decision to step back may become defining, not because it resolves the dispute but because it clarifies boundaries. Private actions now carry private consequences. Titles do not convert liabilities, names on accounts matter. For those at the center, the path forward is uncertain. Legal processes rarely move quickly, but they move steadily. Each filing narrows options. Each response creates record. Outcomes are shaped less by dramatic moments than by consistency over time. And then there is legacy. Reputation is not formed in a single incident. It is shaped by patterns, responses, and accountability when pressure mounts. This situation, still unfolding, has become a test of all three. Whether it ends quietly or escalates further will depend on decisions made away from cameras, guided by counsel rather than commentary. What is undeniable is that the safety net many assumed existed is no longer in place. The margins are thinner now, the scrutiny is sharper, and the consequences are real. Those watching closely know this story is not finished. More filings are expected, more details may surface, and the line between image and evidence will continue to be examined. Because once independence is claimed, every outcome belongs to the ones who claim it.